Okay, so let's get started, and we'll go from there. My understanding is that these types of seminars are becoming much more slight just because people are coming online. In fact, we have 52 people who are joining us today online. So I'm performing for a whole bunch of other people here in addition to yourself. So what are we talking about? Today we're going to talk about something which I frankly think is incredibly relevant to agents. And what's more, it's going to be something that I'll bet you anything you don't know. That is to say, when you leave here, it's not going to be a chattels and fixtures discussion. What is a chattel? What is a fixture? And you guys have discussed that 17,000 times, and you probably do it in your sleep. The goal of any of these sessions is to teach you something new, something useful, something that you may be able to use yourself as you kind of go forward. So I appreciate any feedback you guys have at the end of this if you find that there's anything that I've missed out on or anything else. So titled this, Protecting Your Commission, How to Keep It, How to Enforce It. A bit about our company. We're awesome, absolutely awesome. Always remember that we're awesome. Also, I'll just pause here for 1 second. This is actually an old one, 2 weeks old. We now have a brand new location in Mississauga. We have just started, I don't know if you guys are aware, we have a partnership with Walmarts across the country. We're open within their stores. And as of this week, I'm happy to announce that we now have a similar relationship with Loblaws, and we opened up our first Loblaws location, which is located now at Winston Churchill and Argentia. So that's just now part of the Access Law family. We're thrilled to have it join and pat ourselves on the back. Let's move on to what you actually care about, protecting your commission. Now, there are two different ways that your commission needs to be protected. The first is protection against loss. That is to say, other people don't want to pay your commission. They just plain are trying to get out of your contracts. And the second is when it really has very little to do with your commission. It's just the deal goes south. The deal just torpedoes. And you're suddenly sitting there saying, I don't understand. I've done all this work. I've spent countless hours, and now you're telling me I'm not going to get paid. And we're going to address both issues today. And the first one is probably something that is less relevant if you are going to be a stellar agent. And the second one is something that affects us all. So with your permission, I'm going to start with point one, how to lose your commission. So let's set the scene. The scene, as I'm going to read, is that a devilishly handsome lawyer, that's me by the way, working away in a desk by candlelight, a warm, smiley grandmother of 17 enters the office, every line of her face speaking to a lifetime of character. And here is the dialogue that goes on every single day. Me, what can I do for you? Grandmother, oh, it's just awful. Let me tell you my story. It starts back in the Civil War. Yada, 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 yada. We get coffee, cookies, God knows what to get the story out. The story finally comes. And so, given the past 4 hours worth of facts I've just shared with you, my realtor is just awful and I don't want to pay commission. And what actually goes on in the lawyer's head, by the way, because these are the stories that we get every single day, right? It's like always like yada, 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 and here's the sob story. Really, we don't care. Like all we're listening for is the legal issue. What I hear from this conversation is, I want out with my realtor. I'm done with my realtor. I don't like it. And the question she's asking me is, how do I terminate my relationship with my realtor? Now, we're all aware that the relationships that exist with realtors can happen informally, but more properly, they happen formally. And they happen formally in two different ways. And you guys have all signed these things, but if you're unfamiliar with it, let me know. You have your BRA, and you have your listing agreement. Both of those bind them to you, or not to you, to the brokerage of which you are an agent, but to you for all intents and purposes. What we seem to forget is that there is legislation in Ontario called the Consumer Protection Act. And the Consumer Protection Act pertains to two different types of transactions. One is an unfair practice and one is an unconscionable transaction. An unfair practice is representing something that is false, misleading, or deceptive to the consumer. So if I turn to you, you're a brand new agent, and if you are able to say to someone, I am a commercial specialist, but you've never done a special, you've never done a commercial deal, and someone says, on that basis, I'm ready to sign and have you represent me with the BRA, is that unfair? Did you effectively lie? You did. You made an unfair statement. And that unfair statement roped someone into the selling of taking on your services. Similarly, if someone says, I charge lower commissions, and then they charge you 5%, is that an unfair statement? Definitely is. There's also something called unconscionable transactions. If you turn to an older person who's suffering from dementia and say, remember you signed this with me. Joe, I lost the paper. Can you just re-sign it again? And the person with early onset Alzheimer's signs it again. That's unconscionable. That's just terrible. Or if you're sitting there and saying, I'm going to take your dog and I'm not returning it until you actually appoint me as your realtor. Terrible, right? Unconscionable. It strikes at the conscience. And as a result, the Consumer Protection Act applies. Now, what does it mean when the Consumer Protection Act applies? Because that's critical to today's discussion as to how it is you can lose your commission. Well, generally, what it means is that Granny can get out of her contract. And Granny can get out of her contract because if you have engaged in an unfair practice or an unconscionable transaction, and you go to a smarmy-ass lawyer like me, who actually understands that there's something called the CPA, you may very well get a letter from the smarmy-ass lawyer, excuse me, my Yiddish is particularly good today, stating, thank you very much. You know how you said that you were a commercial specialist? Well, I've looked it up, and you don't have any commercial experience at all. In fact, I just found out you were just called. Accordingly, you are in breach of the Consumer Protection Act. You have engaged in an unfair practice. And by engaging in the unfair practice, be advised that because I am writing you this letter within 6 months of you having done this, I am canceling the contract. Done. Now, you can sue me when I go ahead and then buy another property and say, I have an agreement with you. But it is a valid defense that I can then bring to the court saying, no, you don't have a contract with me because I canceled it under the Consumer Protection Act. And then a judge, just one second, and then a judge would have to say, well, okay, let's look at the merits. Was that cancellation valid? And it's defense as against your claim for commission. Yeah.
Isn't the burden of proof on you to prove that it was?
Interestingly, no, because the burden of proof, if you think about the way it would work, is that the person who would sue in the first place is the person who has the burden of proof, right? Whoever brings a lawsuit has the burden of proof.
Yes.
And in this case, it's never going to be the person who is canceling the contract who actually has any burden. They're just stating you did breach the agreement. It's then incumbent upon the agent to sue, and then the burden of proof is that they had a contract. And it will be then a question as to whether or not the contract was valid because there's a statutory authority that allows the cancellation of that contract in the event of an unfair practice or an unconscionable transaction.
In formation of lawsuits, yes, you know, but also what has to do is bring the contract to that lawsuit. And now, if you're disputing this argument to whether it is legal or not, now say someone signed it with dementia. As an example, and unknowingly signed something that they weren't of a mental state, to sign. Is it up to the defense in that situation to prove that they weren't able to, that they weren't in the right frame of mind?
Yes,
and,
well,
and then this whole scenario would apply.
It would actually, in this case, be up to both sides to prove largely the same point. Because in order to get a cause of action, you have to claim that there was a relationship between the parties, and then you have to claim damage. And because what we're talking about is whether or not there was a relationship between the parties, both the plaintiff and the defendant are going to be asserting the same point. Plaintiff is going to be saying, I have a contract, here it is, it's signed, thank you very much. And the defendants are going to be saying, you don't have a contract, thank you very much. It may be signed, but there is no A, meeting of the minds because I had dementia, didn't have capacity. Or B, even if I had capacity, you engaged in an unconscionable transaction, thank you very much. And as a result, we canceled it under the CPA. And as a result, in this case, the burden of proof would fall on both sides because they're both equally claiming the same thing before the judge. One saying that there is a contract, one saying there isn't, which is the preliminary aspect of any trial necessary to cause or to claim damage. Does that make sense?
And then you're just fighting based on proof, and then it's a fight.
Then it's a fight. Yeah. It's a fight, but it's a defense.
Yeah.
Remember, your BRA, your listing agreement is almost ironclad, except if you can claim the person doesn't have capacity or if you can claim that there's a breach of the CPA. The CPA can vitiate your claim to commission. Can.
A lot of people just turn around and say, hey, I didn't know I was signing at the time.
We're going to talk about that. I have that as part of this.
I had a couple drinks. That's
We're going to talk about that.
Okay.
I have more. So, breach of the CPA saves granny. So what's the lesson? Well, similar to what Google taught us all those years ago, don't be evil. Don't be evil. Don't engage in unconscionable transactions. Don't engage in unfair practices. And none of you, by the way, should be doing that, right? Like, I know you guys come from a reputable brokerage. You should be holding your head up high. You should be saying, thank you very much. You know, I'm conducting myself with a modicum of respect. I am not going to be going ahead and engaging in an unconscionable transaction or an unfair practice. So that's an easy way to avoid losing your commission or having your BRA or your listing agreement challenged. Now, I always find the really interesting thing is not just talking about what the law is, but showing you case law that actually substantiates and talks about what it is we're dealing with. There's no need to take it, you can take the whole presentation home, or we just send the whole presentation afterwards. So the BRA is a powerful document, and it's very, very interesting, your question, because, and I said just wait 1 second, because this was a case where it was demonstrated to the small claims court that the people who signed the agreement did not know what they signed. And I cannot tell you how often this happens, where someone comes in and says, you know, we brought an offer on this house, they signed a BRA, suddenly it was 6 months that I was in talk to them, they never explained it. My God, it happens every single day. Well, you should be aware that there are times where if you can provide the court with proof that they really didn't understand what they were signing, that it wasn't explained to them, and that's hard to do. There's the evidentiary material that the defense would have to give. Well, the court finds that if you had no knowledge of what was contained in an agreement, that you're not held to it. Non est facto, not my deed. The case I took early in my career had to do with Tilden Rent-A-Car, with U-Haul. I am personally responsible for the fact that U-Haul has now changed its contracts. Why? There is a case, a seminal case, that comes out of the East Coast Court of Appeal. That's not a thing, but one of the courts in the East Coast Court of Appeal. And it was called Tilden Rent-A-Car. And what happened was this. There was a gentleman, a businessman, who came on a flight, and he takes flights every single week, and he went on the plane, and he took a glass of wine or whatever it was, and he went to sleep, and he got to the airport, and then he ran up with 6 bags behind him. He's like, I'm late, give me my car, same place he always rents from. They're like, all right, sign here, sign there. Got his car, got into an accident, destroyed a surgeon's hands, $1.5 million worth of damage. And the insurance company put the car, because he opted for the insurance. He said yes for insurance. The insurance company said, sorry. You have a blood alcohol limit of 0.2 or 0.02. Now, if any of you know, the legal limit is 0.08. In other words, he was far below the legal limit. But the contract stated that his blood alcohol limit should be 0, and therefore the insurance denied claim. And the court said, sorry, non est factum. The fact that you had that in the contract has no bearing. You know that your contract in that case was 6 pages long. You know that no one is reading through all these standard forms. You know that there is no understanding of what it is that's being signed for, and that these types of details are not being called attention to, and therefore you are stopped from being able to rely on those contractual provisions. That's what the court said. Which is why when U-Haul, when I had a client who came up to me once and said, hey, I hit the top of my U-Haul truck and I pay $60 extra a day for insurance, and it turns out that their insurance policy specifically denies hitting things with the roof. And I said, well, show me the contract. And he showed me a 5-page contract without any initials here, initials there, and that's the reason, by the way, you do it now, so that they can say they called their attention to it. And because they didn't have it, I showed you Tilden Rent-A-Car, and U-Haul had to cover. So the idea is that if you think about it, the contracts that we're actually sending forward to clients are the BRAs and the listing agreements and everything else. And if we do not specifically call their attention to what it is that is contained, that we are actually going to be their agent for 6 months and all of the GTA is covered or anything else, courts can find non est factum. They can claim that, thank you very much, the provision that is plainly written here is of no bearing, no force and effect. The provision that says 0.02 alcohol is of no point in effect. The courts can do that if the evidence is such that they can show that it is clear you had not explained it. Now, that's a very hard thing to do. Most people can't do that. But you should be aware that's what this court case did and said. Really interesting. Non-is factum is something that not a lot of people pay attention to. By the way, it is the reason, just as an aside, that I believe in Canada, I have no idea what goes on in the States ever, I don't understand that country at all, but in Canada, it's the reason that I believe that you know your end user license agreements that you use on Microsoft or whatever is Apple, and how many of you studiously read through that? Zero. In your life, has anyone read through that? Zero. And by the way, the reason I'm saying that is if I had a room of 10,000 people and I asked that same question, it would still be zero. And therefore, I believe that there would be a case to be made that if they actually start doing things pursuant to that license, I'd be able to say, Your Honor, yes, there's a license, but there's no expectation of reading it. There's no expectation of understanding it. No, this is not good. Non-is factum. I mean, it would throw the tech world into a tizzy and probably larger ramifications than the legislature would have to get involved, but it's the same concept as what you're doing with your contracts. It's the exact same thing. Make sense? Okay, let's turn our attention to another. By the way, I'm going to get to the good meat, which I know you guys want to hear. And the meat, by the way, is okay. I've done everything right, and my clients are screwing me. How do I claim commission? I promise you that's coming up. Let me just finish up with what you guys can do to screw up. So this is an interesting one. Remax Rouge River. And what happened here was that husband signs BRA, wife buys the property, and they say, well, thank you very much. You guys are acting together as a team. Yeah.
That happened exactly to me.
Okay. Well, here it is.
Yep.
Thank you very much. You're acting as a team. And the court said, no. Agent, you want commission? You sign both people. What happened with you in your case?
Listing agreement. I had the historical signature with the wife. The husband didn't like me because it was a guy.
Okay. And who was the?
I let it go because it was a disaster.
Well, in your case, that would have been okay, because in your case it wasn't a buyer. The person on title, you did actually have down to rights. So under the listing agreement, you actually would have been able to claim commission. It's different than a buyer who's then buying in a different name,
Yeah.
right? But that's interesting. It's an interesting little thing. It happens quite frequently. Listen, just knowing these types of things is important. So from the perspective of you guys and protecting your commission, you're going to make sure that if there are two people on title, you're getting both people to sign. And you're going to make sure that if there are two people who are purchasing, you're going to get both people to sign. It's not enough to get husband to sign. It's not enough to get wife to sign. Because then they can turn around with the other person and go ahead and legally, thank you very much, purchase and deny you your commission. How to keep it. We're on the how to keep it section of our talk. Okay, how to keep it. So, scenario. Having just saved the baby from a burning building, lawyer is now back at his desk thinking of, by the way, this is gold comedy, so I need more laughter here. I'm just throwing that out there. Having saved the baby from a burning building, lawyer is now back at his desk thinking what to do with the actual key to the city that was provided by the mayor. In walks a hardworking realtor looking agitated. Here's the dialogue that takes place. Me, what can I do for you? Agent, oh, this is just awful. Let me tell you my story. And then they tell me about how their grandparents immigrated from Italy in the 1300s. And yada, 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 and they go on. And all the while, I'm watching their lips move while actually answering my email until they get to the substance of what they're saying, which is, my client is awful. They're screwing me from my commission. Help me get it back. And so the past hour worth of chatter goes out my head. I think about what the only thing that matters, which is how do I help this client get over their legal issue. Maybe I'm a sociopath. Discuss that later. But I will tell you what it is that I think. So, how to keep your commission. We're going to address 4 different scenarios. We're going to act what to do when you are acting for the cooperating brokerage, what to do when you're acting for the selling brokerage. Remember, when I say you, I'm talking about you as agents acting for that. So when you are the cooperating brokerage, when you are the selling brokerage, if you want. What happens when the seller defaults and you're acting here? what happens when the seller defaults and you're acting here? Let's go over this and let's strike off the easy stuff, okay? The stuff where you have a contractual right. So the easy stuff is section 2 of the BRA and the section 2 of the listing agreement. And what that says is, it says the buyer agrees to pay commission if the buyer screws up. So the buyer agrees that if they sign a firm deal, and if the buyer, for whatever reason, doesn't come up with the money, and it's the buyer's fault, the buyer will pay its brokerage, that being the cooperating brokerage, its commission. Okay? Simple. That's what it says. Therefore, if they screw up, you can take them to court. That's the answer. You can get your commission. You don't need to give it up. That should be plain as its face. I assume you guys don't have any questions about that, right? Same thing with the listing agreement. If you represent a seller and the seller defaults, which happens, by the way, does happen. Seller defaults for whatever reason whatsoever, then the seller owes you commission. Plain and simple. It doesn't matter if the seller has died and that's the reason they can't do it and they're in probate. It's not about whether it's fair. It's just contractually. The seller either completes or it doesn't. And if it doesn't complete, you're entitled to sue for your commission. Done. This isn't about happiness or whether or not people are trying their best or whether someone has gone bankrupt as a result of. There's sad stories. Yes, it's terrible, but it doesn't mean you don't have your legal rights. You do. And as a result, under the standard agreements, we're able to fill out this chart really plainly. We're able to say that the seller pays the selling brokerage if they default, and the buyer pays the cooperating brokerage if they default under the standard BRA and under the standard listing agreement. Fine. That part there you could have probably figured out, and all of your broker of records would figure it. The real challenge to getting your commissions falls in the other two boxes. That's where the essence of things are. Now, I am going to be able, in the next slide, to answer half of this box for you. For non-exclusive deals, those things that are MLS, there is an answer for that box. Let's turn our attention to it. By the way, I'll be able to answer the other box too, but we'll get to that afterwards. MLS Rule 760. Many of you don't realize that MLS, when you use it, has rules. Actually, you do realize it. You understand that within 2 days of a sale, you have to update MLS, right? That's not a broker's rule. That is MLS's rule. MLS has rules. MLS has a whole series of rules. One of those rules states that within 2 days of your sale, you must update it. Another one says, well, I could go through any number of different rules that they have, but they have formal rules. And those rules are part of the MLS system. And an agent that uses MLS agrees to abide by the rules. One of the rules, and none of you really ever think of MLS rules because you've never really encountered them other than just knowing how to comply. But there is a very interesting rule called Rule 760. Rule 760, I'm going to read it because I want us to actually understand this, says that when the full commission is not paid to the listing brokerage in accordance with the amount stated on the MLS listing agreement, the listing brokerage and the cooperating brokerage shall decide whether to pursue legal or other action against the seller. So let's be clear. If the seller doesn't pay the cooperating broker money, does the cooperating broker have grounds to sue in contract the seller? No, because who has contract with the seller? The listing brokerage, not the cooperating brokerage. So the cooperating brokerage has an agreement with the seller, with the listing brokerage to get the money. But that's all that they have. They don't have any way to compel the seller to pay. Make sense?
Yes.
Okay. But if this was listed on MLS, Rule 760, to which all brokerages comply, states as follows. If the listing brokerage does not agree to pursue a claim as provided in the immediately preceding paragraph, the cooperating brokerage may, within 30 days of closing of the transaction, by written notice to the listing brokerage, require, I wrote this, so I made some spellings, require the listing brokerage to either make immediate payment to the cooperating brokerage for the full amount of the commission payable, or or take such steps as are necessary for the cooperating brokerage to pursue a claim for the commission paid in the MLS listing agreement. Why does this matter? Because oftentimes, if the seller defaults, the listing broker is still trying to win that seller's business. Sometimes. Okay? And as a result, if the cooperating brokerage is reliant on the seller to enforce the commission in order to get paid, but the seller brokerage is saying, no, I want this relationship preserved with this person. This person may be bigger than just this one deal, or alternatively, thank you very much, we're going to seek out something else. I know that just a bit more work and I'm good. It may very well be that the seller brokerage refuses to pursue under its rights because the seller has defaulted. Well, the cooperating brokerage under MLS rules can force the seller to sue. It's right there, Rule 760. Does that make sense?
Should be doing first 30 days.
Within 30 days, yes. But does that make sense? That's your right. So if you are representing the cooperating brokerage and the seller defaults, then you are allowed to go after the seller through the selling brokerage. And the selling brokerage has no option but to go after them if you insist, provided it was listed on MLS and not exclusive. Is that interesting?
So they default on the commission payout after closing,
Or they don't close.
or they don't close.
Or they don't close. Let's say the seller just says, I'm not, we had that this month. We had someone who has a Forest Hill home and they're like, I've changed my mind. I really don't want to sell. I'm ready to deal with the repercussions. That's just what happened. They said, thank you very much. I just don't want to leave my home. I know I have a signed agreement. The cooperating brokerage now has to claim commission. The seller brokerage is saying, we're not sure what to do. We're just going to let it go. Forget it. And the cooperating brokerage is really angry.
So you're fighting with the brokerages at this point, trying to get commission. Well, you essentially, if it's coming to closing, you have two options: to let it go or sue them and get your commission.
Or force the other brokerage to sue them. This is, if you're working for the cooperating brokerage, the only person who can sue the seller is the listing brokerage.
As a cooperating agent, our legal position is against the listing brokerage, who's.
But what's your legal position? Your legal position is to collect any commissions paid.
Based on what they've posted on MLS.
Correct, but that first requires the payment.
Yeah.
So it's a commission trust agreement is there, which says that we will transfer any money that is paid to us, but it has to be paid to you first. The problem here is that the money's not going to be paid in the first place. Therefore, the listing brokerage has no obligation to get money over to the cooperating brokerage if they themselves don't receive the money in the first place. So the question is, what rights does the cooperating brokerage have vis-a-vis the person who is not paying the commission in the first place? And the answer is, they have the rights that the seller has. They can subsume their litigation rights. And they can sue the seller if it was listed on MLS. I've never seen this used, but it's perfectly legal.
Just asking, do you have any experience? How did it go through?
Not a single one, and part of that is because it's more rare for the seller to default than it is for a purchaser to default, right? Because the seller generally has the asset and wants to sell. So when deals fall through, it's about 9 times out of 10, it's the purchaser that's making it fall through. So it's not all that regular that a seller is having things fall through, and when it does fall through, there's usually greater reasons than anything else. But that isn't to say that I won't be using this now that I know about this. I actually only learned about this about a year and a half ago, frankly. Yeah.
No, so.
Okay, so look, that's really interesting now. So now we've answered more of the chart, haven't we? We don't know what to do when the seller defaults and it's not MLS, right? If it's exclusive. Though that happens very rarely because most of these properties are on MLS anyways. So I would almost even move the line over there. So we filled out this section of the chart, we filled out this section of the chart, we filled out this section of the chart. Really, we just have 2 more sections of the chart to fill out. This part and that part. Ready to fill them out? Let's fill them out. What happens? All right. What's your name?
Ellie.
Ellie?
Yeah.
All right. So if Ellie were to stand up because she's been markedly offended by what I've been saying and punch me in the nose right now, what law is she breaking? What is she doing? Why is that not good? Why is that from a legal perspective? What can happen to her? I don't know.
She's caused damage, and you could sue her, she's criminally caused damage.
Okay, well, let's start with the second part. So she's definitely criminally liable under something called assault,
Yes.
right? Which means that what's going to happen? And it's not like a judge is going to magically appear. One of you is going to pick up the phone, call 911. Who's going to come? A police person is going to come. They're going to come to Ellie. They're going to see my bloody nose. They're going to arrest her, and then she's going to go to jail, and then she'll go before a court. And who is it that's suing Ellie at that point?
The government.
The Queen herself. Because what Ellie has done is such an affront to justice, my nose being the beautiful vessel that it is, the Queen herself is offended. And the Queen herself is going to sue Ellie. And if the Queen is successful, Ellie will end up in jail. Does that fix my nose? The 10 days worth of work that I've missed and the fact that I'm no longer able to be on the dating circuit? It does not. How do I sue Ellie? Can I sue Ellie personally? Can I? Sure I can. Now, when you sue someone, there are two things you need to prove. You need to prove damage. Yeah, that's clear. I can do that. I can show invoices. I can show the hospital bills. I can show my days off work and everything else. That's not a problem. But that's the second part. You only prove damage after you have a cause of action, after you have a reason why what they did was illegal or against the law. Why was what Ellie did against the law? Do we have a contract? Not a contract. Is there any statute? Is there anything that the legislature has passed stating that Ellie can't pass any law outside of the criminal realm? They have passed criminal law. There is nothing. There's nothing the Ontario government has. They have never written down that Ellie is not to punch Mark in the nose. So my question to you, I'm just trying to take you through the legal process here before we turn our attention to how we answer these other boxes, is how is it that I can sue Ellie? On what grounds can I sue Ellie? We can definitely substantiate the damage. So once I've sued on those grounds and the judge says, yes, you have a claim, I am able to pursue her for damages. That's secondary. What's the ground? Well, the ground is that, and this is just part of human nature, we like to believe that we are unique individuals. And really the only thing the thing that makes us all the same is our belief that we're unique. It's a bit ironic, but there it is. And the truth is that as wonderful a person as I am, and Ellie no doubt as wonderful a person as you are, the simple fact is that there's been 10,000 Ellies throughout history, and there's been 10,000 Marks throughout history. And over the course of history, 10,000 Ellies have punched 10,000 Marks in the nose. Now, it is the case that over the course of hundreds of years, judges have been listening to Ellies speak, to Marks go to the court saying, Ellie punched me in the nose. And over the course of hundreds of years, these powerful gentlemen, who were called landlords and then eventually became part of the royal courts, developed a concept of equity, that is to say non-written law, where they started to say, thank you very much. Every time Ellie punches a Mark in the nose, there are 4 gold coins that are payable. The system of precedent, the system of case law, and more importantly, what I've just described, the system of tort exists. And the system of tort is just the common law. That is the basis of what makes us different from Quebec and Louisiana. It is the notion that, similar to the Force and Luke Skywalker, there is this notion of law that is all around us, and that things that have been deemed to be illegal over time actually are illegal. So you cannot be negligent in your actions. Does it say that you can't be negligent anywhere? No, it does not. But if there have been enough people who have been negligent enough times in life that the courts have said, negligence is something which is a problem. Battery is hitting someone in the nose. There have been enough Ellies that have hit enough Marks in the nose that they have said, aha, that is the tort of battery. You cannot go ahead and punch someone in the nose. And getting back to the tort that is important for the purposes of this discussion, there is something called the tort of negligence. Negligence is if the court is able to find that you have a duty of care, that someone acts below an appropriate standard, and that it results in foreseeable harm to a third party. So let's now put our position back. Let's go back here and take a look at the buyer. In this instance, if the buyer defaults and you are acting for the selling brokerage, we have no contractual right and there is no MLS rule that allows us to claim. But let me ask you something. Does the seller have a duty of care to the people involved in this transaction? Yeah, like a reasonable duty of care to the people it interacts with. Is it foreseeable that in defaulting on its contractual obligations, it will cause harm, foreseeable harm, to the agents involved? Yeah. Is it negligent to ultimately sign a contract and then not abide by its terms? It's negligent. So in the same way that I'm able to sue Ellie for battery, I, as the cooperating brokerage, would be able to sue, as the selling brokerage, would be able to sue the buyer in negligence. In negligence. In the tort of negligence. And similarly, I, as the cooperating brokerage, would be able to sue the seller acting on an exclusive deal in negligence. It is foreseeable. You have a duty of care to everyone with whom you sign a contract and who's involved in this transaction. It is foreseeable that if you default on this, you are effectively going to cause foreseeable harm to people because you've acted below the appropriate standard of care, which appropriate standard of care is concluding the contract you signed. Is there case law on this? No, not that I've been able to find. Would this be a very interesting case to bring forward? Yes, please bring me one because I would like to make this case law. Yes.
So speaking about tort, what about disputes against commission with another realtor?
Oh, let's talk about that in a second. Okay, I will answer it. It's just I need more specifics about the. Oh, well, let's talk about it now. That question is way too broad. Give me the specific example you're thinking of so that we can probably contextualize.
You end up taking another client, one of your friends who's another realtor tells you to take their clients. You have a friendly agreement with them that you'll split the commission, communicated verbally to each other. You drive them around for a week. Their clients around for a week, which were now both your clients, based on that verbal agreement you had, ends up going a couple weeks later, without telling you, closes them on the house, it gets paid the commission, and
so that wouldn't be tort. That would be now you're thinking like a lawyer, because what you're doing is you're saying, how do I categorize things? All I would categorize that as is I had a contract. Can contracts be verbal? Contracts can be verbal.
Yeah.
Show me that you had a contract. Well, did I take you around? Let's supply evidence. Did I take you around? Yes. Why did I take you around if you had that person? Well, because that guy said it was okay for me to be taking you around. Thank you very much. The court finds that there's a contract. Boom, you're done. So what you have there is a contract between you and another agent for the payment. You're not suing a tort at all. You're suing under contract law. Where's the consideration? The consideration is my hard work for the remuneration so there's no issue there. It's just it's not tort. Don't confuse the two. Tort is when there is no contractual relationship.
Historically, does the working broker or sales representative get paid out in something like that? So you put in the quantum merit of the situation. You work hard and you show them 50 houses, and they end up going and buying another house somewhere else with your friend who had a verbal contractual agreement with you. Does the hardworking party normally get?
Well, I wouldn't think that you would be entitled to quantum merit, just so we're all clear, when we all start speaking English. Quantum merit means compensation for the actual work you've done. But that's not the nature of your contract. The nature of your contract is once something is found, we will split X and Y. Therefore, your damage, you would firstly substantiate that you have a contract. If the court found that there was a contract, then the damages that would flow from that are those that are stipulated in the contract, not some magical quantum merit, because quantum merit is less than, I know what you're doing. You're saying, I just want quantum merit just for the work that I put in. But actually, if you're going to be successful in the first part of your claim, which is claiming that there was a contract in the first place, then you should be entitled to all the merits of that contract, which is we were going to split commission. See if you see what I'm saying.
Yeah.
The damages that you would be claiming are the damages that are stipulated on the contract, not a minimized quantum merit. Quantum merit is when there was no compensation for work discussed in the first place, and the courts then award what they think is fair. Anything else? Any other questions so far? So, I haven't found case law on negligence yet, but negligence, sorry, that's not true. I found tons of case law on negligence. There's thousands of cases per day on negligence. The question is, have I found negligence in this particular scenario? I haven't. Now that could also be because I'm not very good at searching, or who knows, there may very well be, or because so much of this takes place in the small claims court where things are not very searchable and these decisions are not all that known. But I believe that there is an excellent claim. Now, part of the reason that you don't really see these claims all that much is because they're small claims court, as I say, and as we are aware, the small claims quantum and damage is, how much, what's the maximum?
5,000?
25,000. With real estate prices being what they are and with 5% commissions being in vogue, we are seeing that things are going well above the $25,000 mark, which means things are now starting to head into divisional court, which means things are now starting to head into other courts. And as a result, case law is actually becoming more defined as the price of real estate goes up because more and more is being reported. I have no doubt that the fact that I haven't been able to find something this year does not mean I will not be able to find something next year. Okay, now let me turn to the final thing about commissions, which is a mutual release. Agents don't understand mutual releases. I know that's strange because it's a one-page document and there it is. But what they don't understand is the critical component of the mutual release, which is this. There are 4 signature lines on a mutual release. You have to have it signed by the buyer, the seller, the cooperating brokerage, and the listing brokerage. And because there are 4 signature lines, agents being what they are, and like to fill out forms, try to get 4 signatures every time. Is there any reason whatsoever to have the listing or the selling brokerage sign off on a mutual release? I mean, don't get me wrong, the seller and the buyer need to do a mutual release, oftentimes, if the deal goes south. And the commission that's being held by the brokerage is not something that can be attacked by the agents. It doesn't belong to them. It's being held in trust. So the seller and the purchaser will allocate that brokerage commission, that deposit, as they see fit in their mutual release. But is there any need whatsoever, if you believe you're owed commission, to sign this mutual release to help your clients along to resolve this? No. If you don't sign this mutual release, can the mutual release still be signed by the seller and the buyer? For sure. Does that relieve them of responsibility vis-a-vis one another? For sure. All that leaves open is a singular claim, which is your claim for commission. So don't feel pressure when someone is sitting there throwing out mutual releases and them saying, and this always happens, just come on, sign this because the buyer and the seller agreed, let's move. You can simply say, thank you very much, let the buyer and seller agree. Your deal's at an end. But my claim for commission still stands. And I'm going to pursue that, and I have 2 years to pursue that. And thank you very much. I may pursue it through the MLS, Rule 720, or I may pursue it through my own court action, or I may pursue it through negligence or anything else, but I am preserving my right. I am not signing off on this. You are still fine. Your deal is over. You can go to sleep knowing that the only problem you now face is a $40,000 lawsuit for my commission. Thank you very much. You do not need to sign this mutual release when asked in order to terminate a deal. The buyer and the seller can terminate a deal absent the brokerage signatures. The brokerage signatures just absolve the brokerages from being able to claim the mutual release, from being able to claim the deposit. Make sense?
What about canceling a listing agreement?
So
I'm representing a listing. Normally, when you cancel a listing agreement, a cancellation agreement, there's a section for the broker of record.
well, in that case, you need to have the broker of record sign off because the cancellation of a listing agreement is a contract between only 2 people, right? You need to have that cancellation done because a cancellation, what I'm saying here is that there are 4 different parties. And if it's only signed by 2, then it will be effective as against those 2. A cancellation of a listing agreement only has 2 parties. Therefore, if it's not signed, it's not effective. Does that make sense? Okay, so, oh, look at that, there's another case. What's this case? Oh, this is really interesting, this case. This case will answer your rumor. The rumor. Oh, yeah, all right, let's deal with this. I like this case. You guys have heard about this case. You're always hearing about this somewhat, and anyways. So Willard Realty and Foddy. Client signs a listing agreement with the broker. The listing price was not a strategy to induce higher offers. It was fair market value. So they weren't pulling that thing that Dan Friedman pulls from CO2 all the time by listing something at $1 million when it's worth $2 million or whatever it is. And in this case, they rejected 17 offers, like 10,000 below, 5,000 below, whatever else, and they're constantly saying, I will accept only my price. My price is what I want. My price, and there's all this evidence induced to the fact that he kept on saying he'll do it. Suddenly, an offer is brought to him unconditionally at the price, and he says, you know what? I'm not going to do it. And the brokerage sues for commission. The court found in this case that acceptance of the offer is not required to make commissions due and owing. As long as they got the offer that was stipulated in the listing, the full priced offer unconditionally, then the broker had earned their commission. Now people look at this giddily and say, aha, so I'm allowed to claim commission if ultimately I get an offer that's at value. That's theoretically what this says. It isn't. If you read the obiter, if you read the discussion, what it says is there are many strategies that agents employ to determine price. And sometimes that strategy is listing below, or they promise their clients something above by actually going in at a price. And if that's the discussion that took place, you cannot then claim that an offer at that lower price entitles you to commission. Rather, the offer of commission is something which can only be claimed if it was clear that that is what they wanted to accept. So it's a bit of an attenuated case law. It's just an interesting case that I thought I'd bring to your attention. And that is it. So again, we're awesome. And I'm going to leave you with this number. This number is direct to our lawyers that's on call. I'm usually on call, but sometimes I'm not here, and so it goes to someone else. When you call this number, anytime until 8 p.m., 7 days a week, a lawyer is there to answer your questions as you do your deals. It's free support. As you say you're from Royal LePage, and rl@accesslaw.com gives you free status reviews that are done within the day and free new build reviews that are done within the day. It is something for our agents. Actually, that address is no longer current. We moved our head office last month, and we now have a nicer head office just next door. But I guess I need to update my information package. What can I tell you? So that's it. That's what I have. What are the questions?
How about assignments?
Sorry?
So
Oh, we do assignments 100 times a day. Yeah, we're very good at assignments.
Is it part of the deal?
Yeah, of course. Yeah. We do assignment review. We'll do any review for a Royal LePage agent for free and without charge. Well, free and without charge. Free as in without charge. And we'll get it done for you within a day. We have a team of 16 lawyers. We have a team of 60 support staff. We are operating on weekends. We have no problem whatsoever turning these things around. What's more, we have knowledgeable expertise in this area that really surpass other law firms. Yeah.
Do we have to call first, talk to someone, and then?
We have something called client care. Client care, we have a team of 5 people who literally do nothing but answer phones and are there to address. But if you call that line directly, you'll get in touch with a lawyer directly. Like just a lawyer will pick up, often it's me, just saying, hey, what can we do for you? And we just take it in and we'll get it done.
I have an assignment I have to talk to or email you.
Just email it. It will get done within like 2-3 hours. We have like teams that just do this all day. Yeah.
Do you guys charge for odd stuff like status certificate review?
Nope, that's free for you guys.
Really? What about your closing packages? Do you do they range or?
Yeah, but we have a lowest price guarantee. We're look, there's like, if to be blunt, and if we're doing the sales drum, there's about 5 major conveyance firms in Ontario. We're one of them. We're all on the same price. Like if you go to Access Law, or if you go to Stephen Chubb, or if you go to Real Estate Lawyers or whatever it is, we're pretty much all. We have the benefit of volume. It's the same thing as Walmart selling underwear. We're able to offer lower prices just because we do higher volumes, and generally those lower prices are all within the same band. As an example, On a purchase of $500,000, all in, it usually comes to about $1,300 or $1,350, all in, once with tax and everything else. On a sale, it's under $1,000 all in. And we give you a firm price quote when you choose to, before you choose to go with our firm, to the dollar, depending on what the purchase price is. But again, there's not much of a difference between the majors in terms of price. There is in terms of quality, but that's something you have to discover for yourself.